Hi, Mel Henshaw here again, another one of my YouTube videos on current events and my information that's available. This will be the first in a series of videos on documents available in my trial court packet, and information on all packets. Send me an email, youwinincourt@gmail.com, and I'll fill you in on that. But these are important because the first one is the Bill of Particulars. And for me, that's the coup de grace for the just us system. It's even recognized in the Sixth Amendment, although we don't use the Sixth Amendment in the way they'll readily recognize. We use it the right way. That said, Bill of Particulars, nature and cause of the accusation, jurisdiction and venue of the trial court, they can't tell you that. They tell the truth, they convict themselves of treason. And the reason for that is that all we have today are quote unquote commercial crimes, AKA public offenses. And the 9-0 parts have ruled, New Jersey Steam v. Merchants Bank, 6 Howard 344, the Commerce Clause powers of Congress are closely associated with the Admiralty jurisdiction. For those of you who may have missed the day in school they discussed it, Admiralty jurisdiction was a central cause of the American Revolution. And here we are. So if that's the case, it's simple. Article 3, Section 2 bars state courts from exercising admiralty jurisdiction. So where the hell are we when we're in, for example, a traffic court, family court, probate, even a criminal court, quote unquote, if they're all, commercial crimes, and they are, it's 27 CFR Code of Federal Regulations, I think 72.11, identifies them as such, then we got a real problem from the get-go, and that's what the BOP is designed to expose. That's why they can't tell you. So, and it just gets worse. It goes on, they have to identify the elements of the crimes involved. They can't do that because, for example, they haul your ass in there for driving on suspended license. They have to prove you're a quote-unquote person within the meaning of the statute, and that's derived directly from the non-existent 14th War Amendment, all capital letter name, corporation. Okay, I've been mugged, Chase Bank, Shell Oil, corporations, not you, not me. They can't prove it. And if they can't prove all the elements of the crime, ain't no conviction. Gets even worse. Now we want to know who the injured party is. There isn't one. California, for example, who's the plaintiff? The people of the state of California, an undefined entity in the copy of the Constitution currently thought to be in effect from 1879. You go back to the original Constitution, Article 2, Section 1. What does it say? Free white male 21. Get over it, ACLU. Get over it, NAACP. It's a fact of life. That's the nation that we established. And it is what it is, and we want to get back to it as quickly as possible. It benefits all of us. All you idiots advocating civil rights out there are so ignorant that it probably proves without more that you don't deserve to be a member of the sovereign body politic. But that said, you're committing acts of treason by supporting those, the New York banksters in particular, whose agenda is the overthrow of the Constitution and lawful government of the United States. Get over it already. So that said, no injured party there. It gets worse if you're in Wisconsin, for example. I have a case before the 9-0 parts right now. State of Wisconsin is the named party. Hello, Article 3, Section 2, another great provision to get familiar with. What does it say? In all cases, a double L, in which a state shall be a party, the Supreme Court has original jurisdiction. The trial in this case should have been in Washington, D.C., not Milwaukee, Wisconsin. So now we have that, and it gets even worse because now without an injured party, you're denied the right to confront and cross-examine your accuser. And if there's any other right that they think we have other than their right to assistance of counsel, this one is it. So you get your accuser on the stand and ask some very pointed questions, and you get a lot of those when you get my document packets. Send me an email at youwinincourt@gmail.com. You're never going to see a jury, but if in the event you do, you start asking questions like this, it gets embarrassing in a hurry. jury won't even have to leave the room to find you not guilty. So here we are. Bottom line is, what they're telling you is that you don't need to know the jurisdiction. You don't need to know the rules of the game, the elements of the crime, or the injured party. And not only that, you're not entitled to assistance of counsel, at least the State Bar Association attorney who can't do it because that's a stipulation to their jurisdiction. Why bother to have a trial? Get it over with. Directed verdict of guilt, which is what they do in 99% of the cases. Anyway, it just looks a little bit different than what I've just described. That's how important the BOP is, and it establishes, among other things, that these courts are in business. They make profits from what it is that they do with us, and you can't do that. The 90 parts, again, I don't make this stuff up. Toomey v. Ohio, 273 U.S. 510, has said that there must be neutral magistrates. There's nothing remotely resembling a neutral magistrate in any of their damn courts. Can't be if they're in it for profit. Simple as that. Therefore, they're all disqualified. They have no judges that can rule on the issues, and it gets better than that, as you'll hear on later videos. So this BOP, and you get it in first, especially with traffic stuff. You know, you sign the ticket under duress and coercion, as you'll learn how to do, and you send in documents to the clerk of court by mail. And now when you get in there to the arraignment, everything's in front of the judge, aka black robe bastard, and they're going to have a hard time putting you through any competency proceedings to see whether you can handle your own case and proceed pro se, which is not what we do. We appear in propria persona sui juris. But that sets it up, and the DA is never going to answer any of these, yet they have the sworn duty to do it because they're bound by this Constitution and the laws enacted in pursuance thereof. Article 6, Section 2. The case in the common law court is over before it even gets started, and it wouldn't even be filed there. That's why we want to get back to those courts. We get there, they recognize our status, our rights, and the government stays the hell away from us. That's how it's supposed to be. It's a principal and agent relationship. We tell them what to do, not the other way around. And we have an extraordinary, unprecedented window of time here to be able to do that. So that's why I'm working so hard on these documents. I'll explain more of them to you in the next video. Meantime, send me an email, uwinnincourt@gmail.com. Like the video, subscribe, tell your friends, get the word out. We can beat these bastards, and we have the window of opportunity to do it. The more of us that happens, the quicker we're going to get them gone. Thank you.